Good day, viewers. Welcome to another episode of Intimate Conversations with Isa Favor. Do you know, we get to talk about life, we talk about issues that affect us, we educate, we empower, we heal, we do all sorts of things that are needed in life. And today, as part of our education, we are talking family law with specific focus on the office of the family advocate, so that we get to understand that children, when they are born, they have rights. They must be protected, they must be taken care of. And sometimes it happens that when parents go separate ways, they forget that there's a child involved who did not ask to be born, but happened to find themselves there. And who then takes care of the child when the parents are caught up in their emotions and not interested in knowing about the child? The Office of the Family Advocate is there for that purpose. But I'm just highlighting, we've got the family advocate herself, who is here, who will tell us more about what she does and the office that she occupies. And it is Advocate Malala. Yes, I've got it right. Oh, I always struggle with the surname, but I've got it right.
Yeah, you are right.
You're welcome, Advocate.
Good day, Sis Nomsa and the viewers. Thank you so much for the opportunity.
Yes, thank you for honoring the invite. The Office of the Family Advocate, and you are called the Family Advocate.
Yes.
So just tell us a bit about your office, then we'll unpack it as we go along.
Thank you, Sis Nomsa. Maybe I can start with the brief background about the Office of the Family Advocate. The Office of the Family Advocate was established during the period of 1990 to 1992, according to the seats of the High Court. So during 1996, other family advocate offices were established in all 9 provinces, meaning that in all 9 provinces in our country, we have the Office of the Family Advocate. So when we talk about the family advocate is a family law specialist who is appointed by the Department of Justice. The family law specialist who assists the parenting parties when there's a dispute in regard to the care, contact and maintenance and guardianship through mediation. Yes.
Okay. So the offices, let's start with that, the structure. The
Yes.
offices are in the 9 provinces.
Yes.
And in Mpumalanga, it's in Nelspruit.
It's in Nelspruit, and
You
we
have
also
branches.
have a satellite office in Forsman in Witbank.
Okay.
Yes.
All right. So what it means then is that if parents or there's a need to intervene, they either go to these 2 offices.
Yes. Let me start by saying that when we assist the parents, we follow the jurisdiction of the child, where the child is residing.
Okay.
For an example, if the child is residing in Witbank, it means that the magistrate who qualified to adjudicate the matter is the magistrate in Witbank.
Okay.
If the child is residing in Nelspruit, it means that the parent who want to report or who want to make an application must go to Mbombela Court. If the child is residing in Barberton, the parent or anyone who want to make an application in the Children's Court must go to Barberton Court.
Oh, so they will go to the court, the nearest court of where the child resides.
Where the child resides.
Okay, because I was
Yes.
thinking, when we've got 2, the way the province is so broad, how do you then service the other offices? Okay.
Yes. For an example, if the child is residing in Witbank and then the parent is residing in Bombela, so we cannot say that to the parent, go to Witbank office. We can say that, okay, you can come to our office in Nelspruit and we will take the application and send it to Witbank. Then, however, during the mediation, meaning that all the parties will go to Witbank where the child is staying.
Okay.
Yes.
All right. And in this instance, just so that we are, child, we're referring up to what age?
A child is, in terms of, we are guided by the legislation. So in terms of the Children's Act, a child is a child who is 18 years. If the child is above 18, meaning that is no longer a child, is a major. We are talking about a minor child.
A minor child.
Yeah,
So that is, yes.
yes.
So your office looks at the interest of them up to the age of 18.
Of the minor child and also of the dependent child or
Okay.
dependent children. Dependent children are children who are above 18, but they are still depending on their parents.
Okay.
Yes, so the Office of the Family Advocate also assists in case wherein the child is major, but however there is a dispute in regard, especially with regard to the issue of maintenance, because it's a serious challenge. You find that during the divorce proceeding, the parties, the parents, they enter into a settlement agreement, and after the divorce, maybe when they enter into a settlement agreement, the child was still maybe at secondary.
Yes.
And then after the child is above 18 years, because in our country, like reality is when the child is 18 years, the child is still in secondary, the child is still maybe at varsity.
Yes.
So we cannot say that, or maybe let me go deeper into the issue of maintenance.
Yeah, because
yeah.
I thought, but I thought let me allow you
Yeah.
to start. Let's start from the beginning. So, parents either going through a divorce,
Yes.
or they've never been married, but there's a need for a child because the child has got two parents, and both parents are responsible
Yes.
to make sure that the child is taken care of. It doesn't matter who earns what.
Yes.
They both are liable to make sure that the child is taken care of. So let's talk maintenance. How does then the office assist?
When it comes to, or let me start by saying that when the parents are in a process of a divorce, it's either they come to the family advocate to say, family advocate, we don't have a dispute, we amicably resolve our dispute. Please assist us with the settlement agreement. Then in their settlement agreement, they will also deal with the issue of maintenance. Then when they come to our office, in terms of the Children's Act, both parents are obliged. Is the obligation of both parents to maintain the child. It means that the issue of maintenance, the common law duty of support, does not end when the parents divorce. It continues, and it does not end when the child is 18 years. So even after when the child is 18 years, the parents still have to maintain, and it's the duty of both parents. If they have a means to maintain the child until the child is self-supporting,
Yes.
the child is able to maintain himself or herself. Yes. So when the parties are in a process of a divorce, sometimes it's a challenge because they are fighting. So they come to the family advocate, and the family advocate will assist them with the drafting of a settlement agreement. However, if there is no agreement in regard to the issue of maintenance, it's then that will refer them to maintenance court, and then the parents will report the issue of maintenance at the maintenance court.
Okay, just so right. So yours will be when it's amicable, when they both are agreeing, then you assist them. It's all that. And then, but if then one comes to you, but the other does not come to the party, then it moves to the maintenance court. Am I getting you correctly?
If one parent come to us and
the
then
other
for
one is not
mediation,
willing, the other one is
not willing to come.
Yes.
Let me start maybe by saying that mediation. We don't force parties to come to our office for mediation. And the other thing is, if in regard to the issue of maintenance, because we're talking about maintenance, if the other party refuses to come when there is a need for that parent to come, then we said, okay, no, it's fine. We're going to refer the matter to the maintenance court, because the maintenance court, they have maintenance officers, they have maintenance investigators.
Okay.
Yes.
Okay. All right.
That's the concept of maintenance.
Yeah.
And again, the office of the family advocate, because I've already stated that we deal with care and contact and maintenance. Maintenance, we dealt with it now, and then guardianship. When we talk about care in relation to a child.
Okay, before we're going to go to care, I wanted us to wrap up the issue of maintenance so that we know that we've covered that. So you say you said, and I just to reiterate, so when there is no agreement, then the role of the family advocate is done.
Yes.
Then it moves over to the maintenance court.
Yes.
Then they take care of it.
They take care of it. Yeah, they continue with the case.
They continue with the case.
Yes.
Okay. Now, I want us to wrap it up. in instances where they have not come to you because you said the two parties, they're agreeing, the one they are going through a divorce, they agree, they come to you just to help them draft. Sometimes they draft their own settlement agreement. At what point does your office come in when they have drafted, they've gone to an attorney, they've drafted, you have a responsibility to endorse?
To endorse, it means that we also check the pleadings, because settlement agreement is part of pleadings. So we check the settlement if it's in the best interest of the children or the child. So meaning that even the issue of maintenance, we check if it's there or not.
Okay.
Yes.
Okay. And so if it is not covered, then you will advise,
we'll advise
that
the parties to, it's not in the best interest of the child. Yes.
Okay. All right. So even if you said mainly you look at the minor child, but even the major child,
yes, we call them dependent children.
Okay, because earlier on you mentioned something of dependence, and I wanted you to touch that,
because they're still depending on their parents.
Okay, until what age?
Until the child is self-supporting.
And if the child does not want to move to being self-supporting,
then you have to have a reasonable reason why you cannot maintain your child. Because if the child is still at university, if the child is done maybe with the studies, but the child is not employed, so as a parent you still have a duty to contribute to the maintenance of that child, because the child is trying, but it's just that the child is not working.
At that point, who comes to the family advocate? Is it the other parent or the child themselves, the major child themselves, that they can come to you?
The major children now, they have to go to court and become the applicant in the application, yes.
Okay.
They go to court themselves to make an application to say that, you know what, I still in need of maintenance.
Okay.
Yes.
Oh, okay. But they go to the maintenance court, they don't come to you?
Not to the family advocate, yes, they go to maintenance court, then to report maintenance.
All right. So I think we've covered maintenance.
Yeah.
All right. Then the next one you wanted...
I wanted to discuss about the care.
Yeah.
Because maybe if I can give the brief background about the concept care and contact.
Okay.
Because before the coming into operation of the Children's Act 38 of 2005, the court used to award custody and access, and then they were calling them, it was a parenting authority and the parenting power. Okay. So when one parent was awarded custody and the other one was awarded access is visitation rights, they were feeling like they have power, they have authority, so I can make all the decision on my own. However, the Children's Act introduced the concept care and contact. Okay. It means that one parent will be awarded the residential place. If you are caring for the child, you are providing a shelter for the child to stay. So when we check the provision in the Children's Act in conjunction with the Constitution again, because even the Constitution it also protects the rights of the children. Even in the Constitution, they talk about that a parent must provide a shelter for the child. When you are residing with the child on a daily basis, you are taking care of that child. When the child visits the other parent, that parent also have the duty to care for that child. So meaning that you are no longer having custody. And when it comes to major decision making, now it's both parties, both parents, they have to make decision together. They have to discuss when it comes to schooling of the child, when it comes to health of the child, when it comes to the taking of applying a passport for the child. They have to discuss choosing the school, because it's an issue. Because one parent will choose this school and then the other one will say, no, I don't like this school. So when parties are caring for the child, it means that it's equal parenting, meaning that they are all caring for the child. And if you are a parent who is residing with a child, you make sure that the child is clean, you make sure that the child go to school, you make sure that the child is protected. You need to protect the child from any form of abuse, any form of any harm, any maltreatment. You make sure that you guide the child in a behavior, in a good manner, and you make sure that everything is fine, because you are the one who is staying with the child. That is care.
Okay. What happens then when the parent that stays with the child is neglecting, or the other parent who's not, who has visitation rights, who has access to the child, feels that the primary caregiver is not doing well, but this one refuses and say, no, I am okay. How do you intervene?
Yes, you know, like I said before, if it's the parents are in a process of a divorce, it means that one parent who feel that no, the other one is not taking care of the child, I want to reside with the child. It means that they will, in our office, there is a form, we call it Annexure B. The other parent will complete the form, Annexure B, and then that parent who requested the family advocate will also send the Annexure B to the other parent, maybe via email. If you find that sometimes when there's a conflict, people don't want to see each other, they don't want to talk to each other. So we said even a proof of email is fine. It's enough for us to open the file. Then the family advocate, because there is a dispute, the parents are fighting for residential place, they both want to stay with the child. So at the office of the family advocate, we have the family advocate, we also a legal person, we also have a family counselor, which is the registered social worker. We work together. So if there is a case, there is a dispute in regard to the primary residency, so meaning that the office of the family advocate will call parties, and then they will come for mediation. Even though there's a dispute, we saw that there's a dispute because the main purpose of the family advocate office is to do mediation, is to protect and promote the best interests of the children, because there is also a provision in the Children's Act where it stated that in all matters concerning the child or the children, an approach which is conducive to conciliation, which is conducive to problem solving, it must be followed. So we try by all means to assist the parents to reach an agreement. However, if the mediation is unsuccessful, it means that the parties did not enter into an agreement. So it means that now we will move from mediation to the inquiry. We take all the information, meaning that now we are going to investigate the matter. We even request the particulars of the collaterals, and then again, if there's a dispute,
what are collaterals?
Collaterals are the maybe people that will assist us to write a good recommendation, especially the people that know the parties, that know the families, then maybe the grandmothers, the sisters,
uncles, and all
yes,
that.
the neighbors, the school. We also request a school progress report from the child to check how the child is doing at school, and then again, if there is a dispute in regard to the house, maybe the home circumstances, if there's a dispute, if the other parent will say, no, my child will not stay there because of this and this and this, then the family counselor, which is a social worker, will even go and do home visit to both houses to avoid a dispute, to say that, no, but you know what, you went to mommy's house, you did not go to my house. Yes. And then the other thing, the views of the children is very important.
From what age? When you talk the views,
yeah.
So would you look at a 3-4-year-old, or what age? At what age do you take the views of the children?
Yes, the family counselor, they are expert in regard to the interviewing of the children. So they look at the age of the child, from even maybe one. Maybe you will ask yourself, how maybe the 1-year-old child cannot speak. Yes, but you know, they are trained, they know how to observe. If they know that the child cannot speak, but the other parent will say, no, but there is no relationship between daddy and the child, then the family counselor, which is a social worker, they will do the interactional analysis. So they will observe the relationship between the child and the other parent, that there are allegations to say that no, there's no relationship. They are able to find, okay, we observe, and then the results are like this and this and this. And then after the investigation, then the family counselor will write the report, and the recommendation and give the family advocate to write the report and recommendation. And the recommendation of the family advocate is not a decision. So when the parties or the parents receive the family advocate reports and there's a recommendation, they will not think that they must not think that I won. Now the family advocate recommend that I stay with the child. They need to wait for the court to give the court order, because the recommendation of the family advocate is not a final decision. Yes, it is not enforceable.
Okay.
Yes.
That is why it's a recommendation.
It's a recommendation.
Until it becomes a court order.
Yes.
And then what happens if then one of the parents disregards the court order?
Yeah, it means if there is a provision there in the Children's Act, it states that a parent who have parental responsibility and rights, like, okay, let me even talk about if there's already a court order. So if there's a court order, there's a provision to say that that person will be in contempt of the court order.
Okay.
And will be liable of a fine. Because there is a court order and you decided, if they're saying that, okay, you are going to see the children 2 weeks only, and then you decide that, okay, no.
Don't bring them back when they're supposed to come back. They visited, now they're supposed to come back. You decide, no, they can't come back. I can still transport them to school and all that, which disrupts the child's life. Yes,
so it is very important. Hence, we encourage the parents to communicate, because communication is very important. If, like you said, you are saying that the other parent will decide to say, I'm not taking the children back to the mother, or I'm not taking the children back to the father. So if there is something, maybe you want to extend your holidays, you communicate with the other parent to say that, Daddy, how, or what if, or Mommy, what if, because the children are saying that they still want to be with me. I'm requesting. You are requesting for a favor, because you were supposed to be with the children only 2 weeks. Then if the other parents said, no, but the children must come back because they have a routine. We need stability, because the children must know where they are staying. Because if the child this week they are staying here, next week they're staying that side, there is no stability and routine. However, like, okay, let me also move to the concept of contact, visitation rights, because we have started already. I said that we encourage communication. The parents must communicate, or let me say that the co-holders of parental responsibilities must communicate. Like, even if maybe a parent was supposed to have the children for 2 weeks, then if they communicate, it reduces what? Conflicts. Yes. But if they don't communicate, because contact in relation to a child, it means you need to maintain a relationship with the child. And the other thing, the child must visit you, and then, or you visit the child. Unless if you have reasonable reasons to say, you know what, I don't want the children to visit there anymore. Why? You must state the reasonable reason. Why you don't want the children to visit there? Because the children are complaining to say that when we visit daddy is not available. When we visit mommy is not available. When we visit daddy take us to his mother's place, and we want to spend time with him. Yes.
Okay. Now, and I know that you spoke of that there will also be, if they do not live by, then they will be in contempt. So it would mean that even if the parent who's supposed to have visitation rights, this one is the primary, and this one is supposed to have visitation rights.
Yes.
If they don't ask for or they refuse that you bring the children, and they don't even ask for them, then they will also be in contempt if there's a court order that says this is how the child must visit them.
But the thing is, if it's the parent himself who don't want the children to visit, we don't know the reason why the other parent who is residing with the children can come to the family advocate, because during separation, the parents, let's talk about the parents who are not married, or the parents who are married but they have not yet start with the issue of the divorce.
Yes.
They can also come to the family advocate to be assisted with the parenting plan agreement.
Okay.
Let's say that there was a parenting plan agreement. The parents enter into an agreement, and then they choose to parenting plan. You can choose to register it with the family advocate office, or you make it a court order.
Oh, okay.
Yeah, let's say that there was a parenting plan, and now after the parenting plan, the parent who is supposed to come and fetch the children to have contact with the child
Is not
is not
doing that.
available. The parent is not. The other one can come back, because we are facing challenges wherein we find that the parties enter into a parenting plan. You agreed, they put they both sign to say that we are co-holders of parental responsibility and rights. And we find that after, when mommy or daddy want maybe the other parent to come and sign the document at school, the parent is not available. When the children want to visit that parent, the parent is not available. Yes. So the aggrieved parent can come to say that, you know what, I have a serious challenge. You know what, I agree that daddy must come and fetch the children on weekends or maybe school holiday, but daddy is not available. At school, daddy is not attending, or mommy is not attending meetings. She is not available. So please, I want to terminate the parental responsibility and rights of the father or of the mother, because you know what? When I want to apply for a passport,
they are not there.
They are not there. When I want to sign things at school, they want the other parent. The parent is not there. The parent is not available anyway. Yes, the parenting plan can be terminated.
I wanted to
those
ask
rights
that,
the parental responsibility and rights agreement can be terminated.
Okay. So what does that mean? Because I'm reading here, your thing, it says terminate parental rights and responsibilities.
Terminate the parent.
What does it mean you've terminated parental rights?
The parents who is not available at all. We give them a chance, because if one parent come to the office to say that, you know what, I have a challenge, this parent is not available, we will open a file again. Because maybe the mother want to amend the parenting plan. We will try to call both parties and do the mediation again, and we see what is the challenge, because the main purpose of the family advocate office is to protect the children, the best interest of the children. Because you cannot come to the office and say that, you know what, I want to see my child, I want to see my children, I want to be there for but you are not available. The other parent is struggling. Yes.
So when you've terminated, when we say the parental rights have been terminated, what does it actually mean?
It means that when you want to exercise them, it means that you have to come back to the family advocate office to be assisted.
So, okay, so now the agreement is that the ex-daddy or mommy no longer has parental rights. What does it mean? It means they can't see the child. The one who has now full rights is no longer. What does it actually mean?
When you are co-holders of parental responsibility and rights, it means, especially when it comes to major decision making, it means that you need to communicate. You have equal parenting. You need to assist each other. But if the other one is not there, meaning the rights will be terminated. You are not going, when you want something, it means that you will hear from the other parent if that parent is comfortable for you to exercise those parental responsibility and rights. It means that no, you will not have those rights.
Okay.
Yeah.
Okay. All right. Okay. Then you spoke of one of the things that the office does is guardianship.
Yes, guardianship.
Okay. Let's talk about that.
Yes, guardianship in relation to a child. You become a guardian, especially when you are both. When you are married, you are both the guardian of the child. You administer the child's property. If the child want to apply for a passport, you must give consent. It's the challenge when it comes to guardianship, especially when it comes to Hague conventional matters. You find that maybe there was a court order, and then the court order stated that the one parent will reside with the children and the other one will have a contact. Then the other one decide that, you know what, I'm sick and tired of residing here in South Africa. I want to relocate.
Yes.
I want to relocate. Then it's a guardianship because you both have parental responsibility and rights. You are the guardian of children. So the one who is aggrieved to say that, you cannot relocate with the children. It means if there's a dispute, they go to High Court and make an application. Then the family advocate will receive a court order from court to say, family advocate, then we become involved because there's a dispute now. The other parent want to relocate, and then the other one said no. And also, sometimes we find that there is a parent who relocate with the child without the consent or without informing the other parent. And it's a challenge sometimes because we need to check if the country that other parent relocated to, it does have an agreement with South Africa.
Okay.
Treat.
Yes.
We ask if there is an agreement. We check in terms of Hague Convention matters because some of the countries, they don't have agreement with our country. So it's difficult for the child to come back to our country.
Oh.
Yeah, it is difficult sometimes. So we check if there is an agreement.
Okay. So even if the other party has received a lucrative job offer and and if there's no agreement, then you will not recommend if that country that she wants to move to has no treaty or agreement with SA, what then happens?
It is a challenge. So we need to do the investigation to investigate and recommend to court. Then the court will take a decision because the court is the upper guardian of all the minor children. So if they say challenge and we see that this country is not a signatory country, it means it did not sign an agreement with South Africa. So we said, court, we are recommending like this. The court will take a decision. Yes.
Okay.
And the Office of the Family Advocate also deal with the cases of unmarried fathers.
Okay.
Yeah, the unmarried fathers who are not married to the mothers. Because in terms of the parental responsibility and rights, the mother automatically has full parental responsibility and rights. So when it comes to the father who is married to the mother of the child has full parental responsibility. Yes. But unmarried father, he has to meet certain requirements for him to acquire those rights.
How?
Yes, because he is not married to the mother. So some of the requirements, if he agreed to be identified as the father of the child, if he did not dispute a paternity, he said, yes, I am the father. And then again, if he paid damages in terms of customary law, but it depends on the custom. And again, if he tried to pay maintenance, because we're talking about maintenance, and if he tried to pay maintenance, because other parents, they try, and then maybe the mother of the child said, oh, no, stop, I will be able to maintain my child. Yeah. So if he tried and he was stopped, he can come to the Office of the Family Advocate to say that, you know what, I tried, I was maintaining the child, but she stopped me. I paid damages in terms of customary law, but now she's refusing me to see the child. Yeah. And I agree. I did not dispute paternity. But some challenges, we also have challenges because, sometimes mother of the children, they get angry because they are saying, no, I raised this child alone and you were not there. But what about the child? Because family advocate protect the best interests of the child. So when the father comes to say that, you know what, I want to acquire the parental responsibilities and rights, we assist him. Then it means that we'll assist him with mediation. If the mother said yes, then we assist them with the parenting plan agreement. Because if they are married, automatically when they come to our office, they qualify to enter into a parenting plan agreement because they are married. They are co-holders of parental responsibility and rights. But if the father is not married, when he come, he want to request, family advocate, please assist me. I want to acquire these rights. And we also deal with a Section 22 agreement. If the mother maybe dispute that, yes, the father qualified to have those rights, we can request the mother to say, Mommy, is it fine if you can give him some rights maybe the rights to see the child, maybe the rights to visit the child. Then mommy said yes. Then they can enter into a parental responsibility and rights agreement. And also the grandparents.
Same.
The grandparents, but they don't come to our office. They go to court straight. If the grandmother of the child want to have care of the child, to stay with the child,
because it thinks the parents are not.
Yes.
Yeah.
Or maybe the grandmother want to have access of the child, and then the other parent is refusing to him or her to see the child. They can come to they can go to court and apply to have the rights to be awarded to them, and then the court will send the court order again to the family advocate to say, family advocate, please assist the grandmother want to have care of the child, or the grandmother want to have contact of the child. And we also have challenges because, when things are good, you find that the parents themselves, they request the grandmother to stay with the child. Then when they are fighting, there's a conflict, they are separating, they are divorcing, now the grandmother is a bad parent. Yes. They don't want the child to visit
the grandmother.
Yes, and there's a provision in the Children's Act because we look at the family advocate, we look at the best interest of the child. We check the relationship.
Okay. I wanted to ask then, when you spoke about the unmarried fathers. So I meet my African brother, and then I have a child with him, and then African brother wants to take child
to. Yes.
How does that one work?
So if it is your agreement,
if now things have gone sour, I don't want him to take my child to his country because now he might not bring my child back. How can he approach you as an unmarried father? How do you look into that?
As the unmarried father want to come to our office.
Can they come? He's not from South Africa. We were okay, but now we've now broken up, and then but he's going home to visit home, and he wants to take the child with, and then I refuse. Can he come to you?
He can come to us because he's an unmarried father, and we are representing the best interests of the child. So he can come to us. Then we'll open a file, Section 21 file for unmarried fathers. We will call the mother for mediation. The parties will come, and then we do mediation. If the mediation is successfully, it's fine. We will assist them with the parenting plan because they amicably resolve their challenges. They amicably resolve their dispute. However, if there's a dispute, it means that the unmarried father will go to court where the child is residing. Then the family advocate will receive the court order. The matter will come back to the family advocate again. Then we go back to the issue of investigation.
Okay.
Yes.
Okay. All right. Is there anything else in terms of your office that we have not touched that is critical? And by the way, you're going to come back, ne?
Oh, okay.
I would want for us to discuss the different regimes of marriages.
Okay, yeah.
Yes.
Types of marriages.
Yeah. And that I worked with.
Yes.
I'm booking you in that chair again.
Oh, okay.
But is there, in terms of the Office of the Family Advocate, is there anything else that we have not touched on that you think it's important for our viewers to know?
Yeah, I think I want to go deeper into the best interests of the relationship because the best interests of the of the child is very important because when we do the investigation, we look at the best interests of the child. We look at the relationship between a parent or any caregiver, and then again the attitude of the parents. We look at the conduct of the parents because sometimes the conflicts affect the child. Sometimes parents, when they fight, they think that children cannot have depression. The important thing about domestic violence, because we are guided by legislations. We at the Office of the Family Advocate, we are also receiving court orders in regard to the issue of domestic violence, where the parties are fighting and they have children and they applied for a protection order against each other. So the court will send the court order to the family advocate. Then we'll do the inquiries. Yes, to check how the other parent will see the child. Because if there's a protection order, sometimes in the protection order they will write that you are not allowed to go to parent choose premises, how are you going to see the child? Yes. We also deal with the cases like that. We receive the court order from court to assist.
Okay.
Yes.
Okay.
And maintenance and in terms of the other sections in the Children's Act, Section 70 is a family group conference, and then Section 50 is.
Okay.
Yeah.
All right. Thank you for coming through.
Thank you so much for giving me the opportunity, Sis Nomsa.
Yeah, I believe that we have educated, we have
Yes.
empowered. Just maybe your parting shots, whatever your final parting shots to our viewers, and number two, where your offices are in Mpumalanga. I know the actual physical address of your offices as well as the one in Witbank.
Oh, okay.
First the parting shots, then the location.
Okay, I just want to encourage the viewers to use the service of the family advocate because it's free of charge. They don't pay anything. Family advocate services is free. And the other thing is when we assist them with parenting plan, if there's a dispute again, or is the settlement agreement, if there's a dispute, they can come and then we'll assist them with the settlement agreement or the parenting plan again. And then our office in Nelspruit, we are at High Court Building. And in Witbank, we are in Forsman.
Okay.
Yes, and our number in Nelspruit is 013 101 and 3720.
Okay.
Yes.
Thank you so much for coming through.
Thank you, Sis Nomsa, for giving us the opportunity.
Awesome. Viewers, you've heard it. I think what is most important is that the child is innocent. At whatever point that the parents may have their differences, can we remember the child who is innocent? Let us not let our differences affect or impact on the child negatively, but let us make sure that we continuously remember that the child is innocent in this. They did not ask to be born. We brought them here, so we have a responsibility to make sure that their interests are well taken care of. We may hate each other's guts, we may hate each other and not want to see each other, but we remain parents to the child. So this child must see father and the child must see mommy. So let us just make sure that we take care of that. And when we can't do it ourselves, then the services of the family advocate are available for free.
For free, and maybe I can add something, because after COVID, we are exploring things. Now we are even doing the online interviews, telephone inquiries, teleconference. So we assist them, even if a parent can say that I'm in Joburg, but the child is residing here. So we assist them, we phone them, and then we do online inquiries with Zoom, with telephonic. Yes.
Okay, so there you have it. Help is available. Let's not frustrate the children. Let's make sure that children are well taken care of, because we don't want to raise wounded adults
Yes.
because of our own issues. Until next time, stay blessed.